Utah's conference, A New Future for Antitrust. I'm Marshall Steinbaum, Assistant Professor of Economics here at the university. It's great to have such a wide and diverse audience show up for a conference on what was, until fairly recently, a sleepy subject. In fact, some of the people presenting here today and tomorrow are the ones responsible for that rapid change in the public profile of antitrust and the enormous widening of the set of stakeholders who take an interest in it. So take it from me, you're lucky to be here. I remember the first and pretty much only time in my formal economics education I heard anything about antitrust. That was the fall of 2010. I was taking Chad Severson's excellent graduate industrial organization sequence as an elective at the University of Chicago. At the start of a lecture on vertical restraints, Chad said that the University of Chicago's economics department had a reputation for conservatism, which was something that was almost never mentioned overtly by members of that department, but that reputation was exaggerated, but not in antitrust. He said that that was the one policy area in which the pendulum had swung furthest as a direct result of our own department's influence. I had no idea what he was talking about at the time, and to me, Robert Bork was a guy whose Supreme Court nomination was rejected in the 1980s. But I remember thinking at that time, that doesn't sound right. I bet there's something wrong here. Let's come back to this later. And so I did. And it turned out that my initial suspicion was correct. Chad was right that policy swung enormously in response to the ideological influence of Chicago School economics. But that swing of the pendulum made us substantially economically worse off, as a growing body of evidence shows. The optimistic theories that held that antitrust was rarely needed to ensure the proper functioning of the economy turned out not to be true. Therefore, it's time for policy experts to formulate alternatives to the existing policy regime and to start expanding the limits of the terrain of the terrain that antitrust enforcement covers after decades of contraction. Many have started doing that with active legislative proposals in Congress modifying and expanding existing antitrust law, overturning misguided case law that we now know to have been based on false theories. Both federal agencies and congressional committees are investigating conduct by the tech platforms that would once have been a clear violation of the law, but upon which their current business models have been built. And state attorneys general have undertaken novel cases and uncovered evidence of harm to competition that would otherwise have remained hidden. This is gratifying for those of us who've been told many times over the past couple of years that we didn't know what we were talking about, to leave it to the experts with decades of experience and to stop dredging up old questions put to bed long ago. We've been called nasty nicknames by a well-organized infrastructure and faced insider blockades on publishing our work. One thing I already knew when I started on this subject is that, and that has only been confirmed in spades since I began, is that when you spark an outraged reaction like that, evidently based on little or nothing of substance, you probably hit on something real that needs a good deal of time, attention, public scrutiny, and reconsideration. So we put together this conference to take stock of what's been accomplished in the scholarly debate on both law and economics in the past couple of years, to hear from some critics, to chart the way forward. We have law professors, economists, judges, practitioners, critics, other leading voices, all coming together for a cross-community dialogue, which is a rare enough thing all by itself. It's an exciting time to be doing antitrust for the first time in a long time, and that's only going to grow as the set of interested stakeholders widens. Antitrust has been considered a highly technical subject suitable only for a select few to have a say. While some of the issues are technical, the basic fact remains that something so intimately connected with who in the economy has wealth and power must be up for democratic discussion and debate. The role of us experts and professionals is to inform that debate so that it may take place productively, not to stifle it. I have the privilege of moderating this first panel on the new Brandeis School and Antitrust. But before I start, I'd like to thank the sponsors who made this conference possible: the University of Utah Economics Department, the Institute for New Economic Thinking, Charles River Associates, and the Utah Bar Association. Thank you all for coming. I hope you find this and subsequent panels interesting and informative, and I hope that you'll participate by asking the panelists questions at the end of this panel and at the end of the subsequent panels. We'll go now in this panel until about 11:45, at which point we'll break for lunch, and then we'll have two more panels in the afternoon session. So I'll transition now into introducing our panelists for this panel on the new Brandeis School. I don't know exactly where or who decided that we antitrust bomb throwers should be named for the great antitruster Louis Brandeis. a crusading anti-corporate lawyer, progressive organizer, and subsequently a justice of the United States Supreme Court, who in his career battled and wrote about battling concentrated corporate interests, especially railroads and the Wall Street financiers who controlled them. That era had no better interpreter of the economic reality in which he observed every day and which he knew intimately, and I'm happy to say the same about the members of this panel. Lina is a fellow at Columbia Law School, author of Amazon's Antitrust Paradox and the Separations of Platforms and Commerce, as well as many other articles. Both of those and her other articles, seminal contributions to our understanding of the way that tech platforms operate and the relevance of antitrust or the lack of antitrust to that operation. It may be controversial to say so, but when I first read Lina's account, I found its interpretation illuminating in a way that much of the facile economics writing on this subject was not, because it took a critical rather than a celebratory perspective and teased out the crux of the matter in the way that power is exercised, often the one factor glaringly omitted from economics accounts of these issues. Sandeep Vaheesan is legal director at the Open Markets Institute and a great scholar of the democratic and anti-monopolist character of antitrust, exactly the elements of it most buried under the Chicago School's influence. He wrote the great papers, The Evolving Populisms of Antitrust, Accommodating Capital and Policing Labor, and with Lina, Market Power and Inequality, The Antitrust Counter-Revolution and Its Discontents, all of which have influenced and taught me a great deal, and I'm certainly not the only one. Tim Wu is a professor at Columbia Law School and author of Who Controls the Internet, The Attention Merchants, The Master Switch, and The Curse of Bigness, as well as the coiner of the phrase net neutrality and a former candidate for lieutenant governor of the state of New York. He's a great historian and interpreter of this country's antitrust and anti-monopolist legal tradition. He has his finger on the pulse of how information is transmitted, directed, and controlled, and a leading voice in the current debate about how it should be revived. Daniel Crane is professor of law at the University of Michigan and the author of countless erudite articles on both contemporary antitrust and its history, including the excellent chapter, The Dissociation of Incorporation and Regulation in the Progressive Era and the New Deal, which in my opinion is a cautionary tale about the limits of antitrust after we've determined that corporate charters are available on pretty much any terms and for any purpose. He's a trenchant critic of the new Brandeis movement, exemplifying the idea that a movement benefits from the quality of its finest criticism. Darren Bush is professor of law at the University of Houston and has both a JD and an economics PhD from the University of Utah, making him perhaps the single most qualified and appropriate individual to speak at this conference. He was formerly at the DOJ Antitrust Division and the author of numerous articles on the economics of antitrust and regulation. And finally, Dean Baker is senior economist at the Center for Economic and Policy Research, and I'm pleased to say now my colleague in the economics department here at the University of Utah. He's the author of Rigged, how globalization and the rules of the modern economy were structured to make the rich richer, and he was an early inspiration to me in locating the roots of social problems like inequality in the structure and regulation of markets, a fairly lonely perspective for the last many years. He's been working on it until very recently. I'm very happy to have all of these eminent individuals here to talk about the new Brandeis movement, what it stands for, what it's rebelling against, where the tires need to be kicked before moving forward. The panelists will have between 5 and 10 minutes to introduce their work. Discussants will have 5 minutes to address the panelist introductions, and then we'll have some discussion among the panel, and then open it up to questions from the audience. And we'll start the panel with Lina's presentation.
Thanks, Marshall, and thanks so much. Is this on? Thanks so much to Marshall and Mark for organizing this and for this great panel, which I'm really excited about. I'm currently doing some work with the House Antitrust Subcommittee, so I have to offer the requisite disclaimer that my comments today reflect only my own views. I thought I would begin by just sketching out what I see as some of the key facets of the new Brandeisian intervention. And I think one facet of the current debate that exposes the fissure between the post-Chicago school and the new Brandeis school is the question of whether the rise and prevalence of market power and decline of competition across markets is primarily a feature of under-enforcement of the existing laws, or whether there is something more foundationally awry in the analytical tools and framework currently employed by antitrust enforcers. There are always hazards of generalizing, but generally speaking, post-Chicago folks offer that the problem is primarily under-enforcement of existing laws and recommend more enforcement under the existing consumer welfare framework through greater reliance on industrial organization economics, whereas the new Brandeis School tends to argue that the problem is a bit deeper. I wrote a short piece last year called The Ideological Roots of America's Market Power Problem, where I examined how the doctrinal changes that we've seen in antitrust over the last few decades map onto and reflect a dramatic shift in the underlying assumptions about how markets function and the role and value of market power. So there was a descriptive shift marked by a growing view of markets as these semi-organic entities that are likely to self-correct. There are a whole set of assumptions now embedded in doctrine that offer a pretty particularized view of how markets work. One of the clearest examples is the Brook Group claim about how predatory pricing is highly irrational business strategy. The normative shift, meanwhile, concerned the relative desirability and hazards of concentrated private power. And in the piece, I contrast a quote from one of Justice Douglas's dissents with Justice Scalia's majority opinion in Trinco. And you really see how Justice Douglas is talking about monopoly power as fundamentally being about the power to control. The power to control prices, the power to control outcomes, and he says the Sherman Act is founded on a theory of hostility to that concentration in private hands of power so great that only a government of the people should have it. Justice Scalia's passage, meanwhile, is more of an ode to monopoly power. He's talking about how the promise of monopoly power serves a critical engine of innovation, and it's how something that antitrust should seek to protect the ability to achieve market power and monopoly power. So usually the shift in antitrust that occurred in the 70s and 80s is described largely in terms of legal standards, but I think it's also important to recognize just how starkly the background set of assumptions about the role and effects of market power have changed alongside the empirical assumptions. And I think, given the broad and pretty concise terms in which the antitrust laws are written, the application of those laws turns critically on notions of economic power, such that when suspicion of concentrated market power is instead replaced with reverence for that power, the antitrust laws will founder. Practically speaking, you most clearly see this, for example, in the categorical preference for type 2 errors over type 1 errors. And similarly, I think throughout the doctrine, you see how this shift has played out. I think another way to distinguish between post-Chicago and New Brandeis interventions is that post-Chicago is primarily focused on that descriptive prong, on the empirics. And as we'll hear later, I'm sure, post-Chicago also tends to gatekeep around what methodologies are permitted to have a claim on empirics. But I think New Brandeis is, in addition to being focused on the empirics, also looking at the normative work that the background assumptions are doing. And I think, from my perspective, the post-Chicago view that the idea that we will enter a new golden age of antitrust by only focusing on the empirics and bracketing the foundational questions about what the body of law stands for is misguided. So I thought I would identify a few tenets around which I see some of the New Brandeis energy coalescing. One is the idea that the consumer welfare standard is an ineffective metric for assessing competition. So as a first-order matter, I think there seems to be significant disagreement about what consumer welfare actually encompasses. So you have the traditional Borkian disagreement about allocative efficiency versus consumer welfare. This is often presented as a settled question, but we actually still have FTC commissioners, for example, that are still advancing the allocative efficiency view of consumer welfare. More recently, we've started hearing about consumer welfare being either about consumer surplus or being more about trading partner welfare. There's a question now about whether labor market concerns fit within a consumer welfare framework, with some consumer welfare advocates actually arguing that the term consumer welfare is capacious enough to also include labor concerns. So I think the clarity and determinacy of the standard, which is often what is offered as its greatest contribution, is quite overstated. I also say that a wave of empirical studies in recent years have suggested that the consumer welfare-based approach to antitrust has failed even on its own terms. So it's delivered mergers that routinely lead to higher prices without any offsetting efficiencies. Markups are 300% higher today than they were in the 1980s. New business formation is at a 40-year low. Corporate investment is down relative to profits. And there are a whole set of signs that suggest that the economy is not really working in the ways that you would think it would work if markets were actually competitive, let alone all the terrific research that we're starting to see on labor market concerns and how those are also extremely concentrated. So it's worth underscoring here that although the New Brandeis school sometimes gets portrayed as unsophisticated and economically illiterate, there is a robust set of empirical work that I think is supporting the New Brandeisian critique. I think oftentimes this critique of consumer welfare gets mischaracterized as wanting to use antitrust to solve all sorts of social problems and wanting to incorporate all sorts of social and political concerns into antitrust analysis. And I think that overlooks what I see as a really important distinction to keep in mind between values that are animating a set of laws and how you operationalize those values through rules. So antitrust, I think, is animated by a broader set of values, but that's not the same as saying that, therefore, all of those broader values must be incorporated into the analysis every time you're reviewing a transaction. And I think it's also important to distinguish between saying that concentrated market power has a whole set of political and social ramifications and saying that, therefore, those effects have to also be a factor explicitly in analysis. I think sometimes there is a bit of a false dichotomy that's offered where it's, you can either stay the safe course of consumer welfare or go down this dangerous populist path that is totally unadministrable. But I think there is a lot of opportunity through greater reliance on structural presumptions and shifting away from the rule of reason to actually make antitrust more administrable while also incorporating more of these values in the backdrop. A second principle that I think is emerging is that the new Brandeis focus on anti-monopoly is broader than just antitrust. So antitrust is a law enforcement regime, which is pretty limited as a policy tool, but I think the anti-monopoly framework is more focused on creating checks and balances throughout the economy. In the US, there are a whole set of competition levers that are embedded across the federal agencies that I think it's also important to revitalize. So the DOT, the USDA, Treasury, FCC, all of these are in some ways are competition authorities that have important ability to structure markets in their relative domains. Tim has described some of these tools as competition catalysts, which I think deserve a lot more focus. And I think beyond just competition, anti-monopoly policies are also focused on, just the structure of power more generally. So, where are instances where you have to create countervailing power and ensure that organized labor is able to thrive? Where are areas where we actually need to regulate monopolies through traditional non-discrimination rules? So I think there is a very rich anti-monopoly toolbox, and antitrust is one key tool, but not by no means the only one. And lastly, I'll say that I think we need to think seriously about the institutional structure of antitrust enforcement. In the US, we effectively have a common law regime for antitrust, which I think is somewhat of a historical anomaly and I think is also not good for antitrust. I think we're starting to see more recently how generalist judges are really not able to incorporate new learning and incorporate the reality of how markets work into the antitrust rules that they're delivering. Back in 1911, the Standard Oil decision, which introduced this kind of rule of reason notion, was actually a decision that was viewed by Congress as a power grab by the courts. Congress was very alarmed that this decision was a mark that courts were going to put themselves in the driver's seat of deciding what conduct constituted, an unreasonable versus reasonable restraint, and they worried that this would, surrender too much power to the courts. And pretty much the day after this decision came down, Congress started debating the need to create a new administrative agency, which ultimately became the FTC. The vision that Congress had for the FTC was of an administrative agency that had, expansive fact-gathering powers and would constantly monitor markets to ensure that the antitrust rules were keeping pace with new market realities. For various reasons, which Dan Crin has described in some of his work, the FTC has failed to live up to this mission. But I think now is a really important moment to reconsider what role the FTC could play to rebalance this kind of common law focus of antitrust. So I'll leave it there and look forward to hearing from the rest.
So to start off, I'd like to thank Marshall and Mark for organizing this great event and inviting me to participate on this panel alongside these illustrious individuals. Sorry. It's a real honor to speak and participate in this discussion. So I'm going to rehash a lot of what Lina said from a somewhat different perspective. I think our ideological alignments are pretty similar, but I'm going to attack the problem from a different angle, and I hope what I say is not too repetitious. So I think in the past few years, we've really seen extraordinary changes in the terms of antitrust debate. We've gone from a place where this field was deeply technocratic and there was little or no public or popular interest to a field that's now the topic of legislative debate and even the stuff of presidential campaigns. And I don't think we've reached a consensus yet, but I think there is broad agreement that antitrust at present is not working. I think the two factions that would disagree with that are the corporate defense bar and the libertarian right, so I don't want to overstate the point. There are the people who still believe that the system is working quite well. But in light of this broad agreement, the question is increasingly, what do we do next? Is it simply a matter of renovating the existing framework, basically incorporating the latest empirical findings into, for instance, the horizontal merger guidelines, and maybe stopping mergers at a somewhat lower concentration threshold, or do we need to do something more fundamental? I submit that we need to do something more fundamental. I think the empirical deficiencies of the current consumer welfare model are only one of at least three important deficiencies. I think there are three falsehoods that permeate all of consumer welfare antitrust. And they're so profound that we really need to reconstruct the field rather than simply add epicycles to the current broken model. So the first falsehood is the false history on which consumer welfare antitrust is based. If you look at the legislative intent of the Sherman Act, the Clayton Act, the FTC Act, you'll see that the congressional debate over corporate power was rich and broad. And there was a clear desire to constrain the power of the trusts and monopolies over consumers, sellers, rivals, and citizens. And a number of scholars over the years have documented this legislative intent. So people like John Flynn, Eleanor Fox, James May, just to name a few. And so Congress had an almost quasi-constitutional vision for the antitrust laws. The antitrust laws would constrain corporate power in much the same way the federal constitution constrains state power. And John Sherman famously said, if we would not submit to an emperor, we should not submit to an autocrat of trade. Starting in the 60s and really accelerating in the 70s, a group of scholars, most notably Robert Bork, engaged in a massive act of historical revisionism. They took this rich, multifaceted legislative record and distilled it down to the neoclassical concept of consumer welfare. What's interesting is economists in the late 19th century and early 20th century played virtually no role in enacting the antitrust laws, and to the extent that they engaged on the topic, they opposed the enactment of these statutes. And furthermore, they hadn't even developed the idea of consumer welfare and allocative efficiency. So what Bork argued was Congress incorporated the knowledge of people that it had not consulted and incorporated an idea that was still at best in its embryonic stage. In some ways, Bork's audacity is impressive. So James Boyle wrote in the early 90s, those who wrote and passed the antitrust statutes believed enormous concentrations of economic power to be inherently subversive of the American Republic. But this is exactly the kind of egalitarian claptrap Mr. Bork will not tolerate. Consequently, he feels free to apply the wisdom of modern economic analysis to rectify the errors of Congress and the courts. So consumer welfare is based on false legislative history. And as a brief aside, I find it a little bit ironic that self-described progressives in the antitrust community actually, at least some of them, defend consumer welfare and indirectly defend the vision of Robert Bork. I can't imagine an area outside of antitrust law where progressives would be making common cause with Robert Bork. The second falsehood at the heart of consumer welfare antitrust is its conception of the marketplace. So more than a century ago, the legal realists showed that the state constructs and structures the market. Property, contracts, and yes, even corporations are creations of the state. They do not exist in a state of nature. The state defines the scope of all these entitlements and provides state-backed power to turn these theoretical entitlements into practical realities. And the Supreme Court in the mid-20th century actually recognized that the state decides what is legally protected, the scope for protection, and how to enforce legal entitlements. So the decisions I'm thinking of are Shelley versus Kramer, which struck down racially restrictive covenants in housing, and Goldberg versus Kelly, which recognized that the meaning of property was not static and actually changed and could be modified over time by state action. I read a book recently by the legal scholar David Kennedy, and I think he nicely captures this idea. He writes that it is rent all the way down. Everyone's bargaining powers arise from the distribution of legal entitlements. Since it is rules and rents all the way down, there is no principled or analytically precise way of figuring out what is background and what is distortion. Unfortunately, consumer welfare antitrust, and really law and economics more broadly, doesn't reflect the teachings and wisdom of legal realism. Instead, it actually naturalizes a lot of the state construction of the marketplace. The common law is taken as presumptively natural and efficient. So you see this in language like spontaneous ordering. The marketplace simply emerges, and the state intervenes after the fact. And it intervenes in response to one of two things. The first is, this is a more optimistic account of state action. The state responds to correct market failures as defined by neoclassical economics and push markets closer toward neoclassical ideals. This is generally associated with center or center-left thinkers. The less optimistic and frankly downright pessimistic view of the state is the state simply promotes rent seeking. So certain special interests lobby the state to enact laws and regulations that advance insiders' interests at the expense of the broader public. But this fundamentally ignores the state construction of the marketplace and pushes laws and rules of property, contract, corporations, and torts into the distant background, deeply submerging the fundamentally state-created nature of the marketplace. And Duncan Kennedy nicely captured the ideology of law and economics in a 1987 article. He wrote, "The judge made private law rules that define the market are really just the common laws that stood at some hypothetical moment in the 19th century. But these rules have a peculiar, almost sacred status as symbols of the efficient market solution. Most economists don't seem to have or to feel the need for any knowledge of their content or of the reality of their supposed inner responsiveness to the ideas of property and contract. They appear as neutral background in everyone's interest, efficiency, that is constantly threatened by the more partial, political, interest group-based or ideologically based initiatives of legislatures." So to distill it, there's a simple dichotomy in the law and economics ideology. Judges and common law decision-making are presumptively natural and efficient. Legislatures and statutory enactments are artificial and suspect. So this is the second falsehood, a false conception of the marketplace. The third falsehood goes back to what Lina brought up. This is the false economics at the heart of modern antitrust. Since she already discussed predatory pricing, I'm going to focus on mergers. So a raft of empirical studies that have really taken off in the past few years, but that existed prior to the recent research, has found that mergers often raise prices and that concentration is associated with higher markups. So mergers on net are harmful to consumer welfare, and this is especially true in the case of mergers in highly concentrated markets. And on the flip side, they typically do not create efficiency, so they don't yield the promised efficiencies of scale and scope that merger proponents often present to the public as well as the antitrust agencies. The economist Melissa Schilling reviewed the empirical literature and concluded that investment bankers seem to be the only consistent beneficiary of M&A activity. They take a cut of every big merger and often create firms that are less efficient than they were pre-merger and that have more power over price and wages. Unfortunately, consumer welfare antitrust has not really reckoned with this empirical research. Instead, it makes strong conclusions based on hypotheses. Mergers are presumptively beneficial, they yield productive efficiencies such as economies of scale, they don't lead to higher prices or profit margins, and to the extent they enhance market power, we can always trust the marketplace. New entry will simply defeat any attempts to raise price. So there's a major disconnect between consumer welfare economics, heavily based on really hypotheses and deductive reasoning, and the actual literature being developed by economists, which is inductive and empirical. And I'd like to mention that the rule of reason, which is the default framework in antitrust today, is often trotted out as an illustration of empirics in action. Unfortunately, if you look at how the rule of reason is applied, it's far from empirical. Oftentimes, it involves powerful corporations retaining lawyers and economists to come up with just-so stories for a particular merger or particular form of conduct. And Judge Koh's recent decision in FTC versus Qualcomm is very telling. So both the FTC and Qualcomm retained highly paid economic consultants, some of the leading names in the field, and Judge Koh, in a couple of paragraphs, dismissed the testimony as basically irrelevant and out of touch with the facts that were at issue. So there's a big disconnect between the sort of general presentation of the rule of reason and how it works in practice. So I'll wrap up by saying that if we want an antitrust that distributes power broadly and equitably in the political economy, we need to reconstruct the field from the ground up. And the new antitrust has to be based on at least three fundamentally different foundations. First, we have to return to legislative intent. Second, we have to discover legal realism. Economics and politics are inextricably linked. And third, we have to embrace empiricism as an aid to making laws and regulations. Unfortunately, we don't have to start from scratch. Post-war antitrust, at least imperfectly, embrace these ideals. It's an important template on which we can build.
All right. Hi, everybody. Thanks. Is this mine on? I think so. Oh, it is on. Okay, good. Well, thanks for having me here. I love coming to Utah, and I want to thank the organizers. And, you know, there's something important about having conferences about rethinking big issues outside of Washington. Everyone says it, but it's kind of true. There is sort of a sense of freedom that people feel outside of Washington or even the East Coast to kind of loosen up a little bit, say what you want to say a little more. And so, yeah, I think it's really important that you're holding this, and I want to thank you. So, I'm a student of intellectual movements in American history. And that study makes me think that the neo-Brandeisian or the antitrust revivalist movement is at a very sensitive moment, and a moment where many intellectual movements have in fact foundered. And there is a strong tendency among American and even generally human intellectual movements at a moment like this to engage in a sort of premature triumphalism. You know, people are starting to talk about your thing, you feel this kind of excitement, you've managed, and you know, we've all heard this, to completely theoretically eviscerate the other side and leave them gasping for breath. And it feels good, but there's a real danger in that sensation because it can make you think that the movement has won, and obviously everyone will see the truth, and the new day will come. Could not be more important at a time like this to lay out in, I hesitate to say, but practical terms and in workable terms and in institutionally lasting terms, what the movement is going to do and mean in a way that can be lasting. And I don't only mean antitrust. I think this happens across intellectual movements or across exciting moments that really, when you look back at it, what did they really leave behind is what matters. Now, you asked earlier on, I don't know where this neo-Brandeisian label came from, and I think it's an interesting point. My own writing about it came from my study of the New Deal, and particularly the second New Deal, and I won't go too much into it, but the group that decided they needed to overcome the sort of failed central planning approach taken by the first New Deal, styled themselves the neo-Brandeisians. And their idea was antitrust revival, and its most powerful manifestation ended up being Robert Jackson and Thurman Arnold, along with influence through a lot of legislative reforms. And that group, I think, sets the most powerful template, at least for what it means to leaving a lasting influence over institutions and the law. Now, the second New Deal is a pretty high bar. I won't deny that, but I think the people engaged in this who are interested in trying to leave a mark need to compare or hold that bar up and compare it with other sort of failed efforts that generated very powerful entrenching criticism, but no institutional reform, no statutory reform, no real lasting change. So that said, what am I contributing to this? I think we have a lot of work to do. I want to pick up on what something that Lina said that I think is really important. I think the antitrust revivalist or neo-Brandeisian movement has done a couple of important things. All American revolutions style themselves as counter-revolutions. Even the original American Revolution began by saying, we want our rights as Englishmen, which have been denied to us by the king. You know, the ancient and inevitable rights by the Magna Carta, and then eventually it transformed to something else. And so throughout the originalists and so on, and the list is long. And I think that is one of the powers of this movement, and the right thing to do is to link itself to the original, some of the early intent of the antitrust laws, some of the neglected intent of the Clayton Act, in fact, to strengthen the Sherman Act, so the obvious concerns with concentrated power, both for political and economic reasons in the Sherman Act. I think this, and summoning back the spirits, the great, some of the very impressive people who were involved in enforcing and developing the laws, is a very important baseline for where we start. But to pick up on what Lina said, I think there has been great success in trying to outline what the values are of antitrust revival. They are, among others, a return to the concern of concentrated power as a problem that the Sherman Act and the other antitrust laws were interested in and of itself. A return to the sense that there are political as well as economic consequences from excessive concentrated power, and a return to an enforcement tradition that is in some ways more legalistic, that is concerned with, to use old-fashioned words, villainy, predatory practices, the kind of things. And one reason I think Brandeis is important for this is Brandeis, even though he was very dedicated to empirics and facts, also was dedicated to the idea that there was an ethical or moral component here. And it didn't mean that's how you stated your case, but it did mean you brought cases that made sense and resonated to a broader a swath of the American population, of reflecting law's traditional role in fighting unfairness and wrongness and conduct that should not have happened. He was not a bloodless guy when it came to the antitrust laws, and neither have the most successful enforcers ever been bloodless. So I think those are some of the values, but I think there's a big gap, and a gap that it is on duty on us who think of ourselves as revivalists to fill, to say what will it mean to enforce this law? What do you take to the courts? What do enforcers look for and think for? And what do they say is their prescription for how courts should decide things? My own views in the paper I posted here suggest that we should return to a conception and a phrase, protection of the competitive process, which I think is more in line with what the antitrust laws were intended to do and what, at their best, they have done. It puts the enforcer and the judge in a different position. I guess that's where I'd start. Consumer welfare standards, a consumer welfare-centered antitrust, at some level is outlandishly ambitious, which is why it ends up doing nothing. Because the idea of trying to assess the welfare effects of anything that is ever done anywhere is actually an almost impossible project. If you have coffee, I'm trying to think of something random. I decided to just take an example. Economists have always had trouble understanding, or many economists have debated whether theft is really a harm. The reason being, there's negative welfare effects. Money's taken from one person, but it's also just a wealth transfer. Because, and usually a poor person's getting more money, so it's redistributive. And so, if you want to fully analyze the welfare effects of almost any situation, frankly, it's almost an incredibly ambitious task. In practice, to make it worse, most of the things you care about are almost always immeasurable, unless they're prices. And this has been the great problem with consumer welfare, and I don't want to add to the list of flaws, but most of the harms you care about most, exclusion, a breakdown of the competitive process, an excessive concentration of power, most of those are frankly extremely hard to measure. And in cases where they've done things, it ends up being fudged one way or another, or by a return to this protection of the competitive process in a case like Microsoft. So I think that we need judges and enforcers to put themselves more in a position which, frankly, they often are in reality, which is more like a referee in a sports match. There is ongoing conduct, in the marketplace. People come in to complain that something was done wrong, and essentially, it's hard to get past the idea that you're calling fair or foul, or that you're enforcing a series of rules as to what is unfair competition, or what is things that go beyond the norms that should govern the marketplace and competition in the marketplace, and therefore interfere with the competitive process. Now, I can elaborate on that, I realize, but it's an important distinction, because what I think we need to do in order to have this antitrust project succeed is return to what I would call a process-driven approach to enforcement, as opposed to a welfarist approach to enforcement. Now, I don't want to get into, you can use the label, consumer welfare can label, some people are very stuck on consumer welfare, and there's some danger of people who are dedicated to reviving antitrust killing each other over these two words. You know what I'm saying? And whether you say them or not is become like a badge of, so, I prefer not to have people who want to revive antitrust kill each other. But what I do believe is that we should move to this process-oriented model. I outline it better in my paper, where you are trying to figure out whether the fundamentals of the competitive process were interfered with, and develop a jurisprudence on that. Now, it's a lot of work. There's a lot of gaps in what I'm saying, but that, I think, needs to be our path forward. Could be another route, but we have to get into the details. And I'll end this by saying this is what the Chicago School did so well in its antitrust movement. Is not only did they have a series of ideas and a series of values, everyone market basically sovereign and so forth, but I think more importantly, did the work. Aaron Director assigned everyone to a different doctrine of the antitrust law and said, what is the Chicago approach to this, right? And then essentially, Robert Bork put them all together in a treatise in some level that was very readable, and he's writes very well, exciting ways, and it was in that way very well done. And I think that if the neo-Brandisian movement hopes to have success, antitrust revival hopes to have success, it has to get into figuring out for every doctrine, what is the approach going to be. And we don't have to have a consensus and like this is what we voted up or down, but we need to do the hard work to make this movement real. Thank you very much.
Well, don't clap for him just yet. I mean, we haven't interrogated what he said.
I don't know, my mic isn't working. It was never working.
Well, thanks very much to Mark and Marshall for organizing this conference. I'm delighted to be here. Tim has invited us all to loosen up and say what we really think, being out here in the great American heartland, and so I will take him at his word. So I think I was invited to this conference to play the role of the curmudgeonly Chicago School naysayer. To use Sandeep's language, I am the rolled into one, the corporate defense bar, and the libertarian right. So that's why I'm supposed to be here. But actually, I don't want to start by playing that role. And the reason is that although I'm certainly not a neo-Brandeisian or a paleo-Brandeisian or Brandeisian by any description, I think it's really, really healthy to be having this set of conversations, not just here today, but more generally in American society. The antitrust establishment, of which I certainly consider myself a member, has been far too insular, too self-assured in its perspectives, as Marshall said in the beginning, really unwilling to hear alternative perspectives and to engage with first principles. And as someone who really does believe deeply in competition of ideas and of products and services, that's not good. We need to have periodic discussions about what this enterprise is all about, to hear from a plurality of voices, and to reimagine what it could be and ask ourselves, is it in the right place? So I'm actually really happy that this conversation is happening nationally, and so I don't want to just be a naysayer here. The way that I thought about this for the paper I wrote for this conference is the following. One of the difficulties in thinking about the Neo-Brandeis School is identifying what it really is. And if you think about the contrast to Chicago, and both Sandeep and Tim have sort of mentioned the roots of Chicago, I mean, it really goes back to the 40s. I mean, Aaron Director's project started in the 40s. Director and Levy write this article in 1956 in the Northwestern Law Review. It's disclosed what the project is. We know where it's going. And they spend 20 or 30 years in the wilderness writing a big volume of scholarship before the Supreme Court starts taking their ideas into law. Now, Lina, Sandeep, and Tim are three of the people who've done the most right now, sort of the early work on the Neo-Brandeis School. They've articulated lots of things already, but it's still a very small body of scholarship. And we don't have judicial opinions on it yet. We don't have statutes. We don't have agency rules or administrative actions on it yet. And so it's a little bit hard to sort of look at the target. What is this thing that we're talking about? And so in the spirit of that, my paper goes back to the original Brandeis and tries to ask a series of questions of the Neo-Brandeisians in the vein of, here's what Brandeis was all about, and is this what you want as well? So the first thing that I want to raise as a question for the Neo-Brandeisians is, how big is the curse of bigness? What's its domain? Remember, Brandeis's famous line is, the curse of bigness. Bigness is a curse. And I've heard a lot today, and I've heard a lot in the writings of people associated with Neo-Brandeis about the curse of bigness from Amazon or Google or Facebook or big banks or big insurance companies or big pharma. But for Brandeis, who saw himself as the heir of the Jeffersonian tradition in American politics, bigness was not just about big business, it was also about big government. Remember that Brandeis on the US Supreme Court votes to strike down key elements of Roosevelt's New Deal. He sends a note to the federal government, to the White House, after voting in 1935 to strike down the National Industrial Recovery Act. He says, this is the end of the business of centralization, and I want you to go back and tell the president that we're not going to let this government centralize everything. It's come to an end. Brandeis thought that bigness was a curse, whether that bigness was in business or in government. So let's contrast now what he struck down in Panama refining to the Green New Deal. Okay? In Panama refining, he struck down a statute that gave the president very limited authority to prohibit shipment and interstate commerce of hot oil, right? The Green New Deal would go many, many times further than that in enabling the federal government to control the petroleum industry, right? So are the Neo-Brandeisians going to be consistently anti-bigness, whether we're talking about bigness in private industry or bigness in government? Now, it's fine for them to say no, right? You don't have to be consistently Brandeisian. To Brandeis, these were paired concepts. In the Jeffersonian tradition, these are paired concepts, right? So the first question I have is, what's your broader view about bigness and power, not just in business, but in government and in society more generally? The second question I want to ask is, how candid are you willing to be about the trade-offs? Right? One of the big criticisms of Robert Bork, and we've heard Sandeep talk a little bit about how Bork may have misinterpreted the legislative history of the Sherman Act and sort of put a Trojan horse into the consumer welfare standard. So one of the big criticisms is Bork took an idea that was very, very sellable in the 60s and 70s, which was consumer welfare. And by the way, Nader was running on the same agenda, right? Consumers at the center of everything. So this was a sellable idea, consumer welfare. But then if you read the Antitrust paradox, he changes it into efficiency. And so the question was, like, was he sincere about what he was doing, and how should we take it? Well, how sincere, how direct are the new Brandeisians going to be when it comes to the question of your goals, and particularly the trade-offs that will inevitably arise between an anti-dominance position, which is what Lina describes, and consumer benefits? So when there's an inevitable case, and I refer you to Lina's excellent article on the separation of commerce and platforms, where she says in her introduction, look, I think that lots of times this will be good for consumers, but there could be times when the anti-dominance idea of separating platforms and commerce will possibly mean that there are losses of efficiency. Are you going to take that on dead center and admit that there are times when a particular ideological vision for antitrust may cost consumers something? Brandeis himself, I think he equivocated about this. If you read The Curse of Bigness, Brandeis says, well, I think economies of scale are overrated. I think oftentimes if they exist, they're captured by producers and not passed on to consumers. Right? He sort of didn't want to own it explicitly, that what he was proposing might sometimes lead consumers to pay more or see losses of innovation. Not so much learned at hand in the Alcoa decision. So in the Alcoa decision, Learned Hand writes the following: throughout the history of these statutes, it has been constantly assumed that one of their purposes was to perpetuate and preserve for its own sake and in spite of possible cost an organization of industry in small units which can effectively compete with each other. Are you willing, as neo-Brandeisians, to say, look, there are times when what we are going to do is going to lead to higher consumer prices? We're going to blow up Amazon Prime, and that means no more two-day shipping. Sorry, folks. That's the price of having an industry that is not dominated by a single large firm. Okay? So that's the question I have on the table. And then the third question, and both Lina and Sandeep have talked about this at some length already, is empiricism. So outside of antitrust law, what is Brandeis really known for in law? The Brandeis brief, right? Mueller versus Oregon, the idea of bringing statistics and data to judicial opinion making, right? Brandeis is an empiricist, and Brandeis says, I follow the facts, I don't follow a priori theory. So is that a commitment that the neo-Brandeisians are prepared to make? That is to say, to follow empiricism wherever that may lead them. If empiricism then turns out to find that vertical integration is not a problem, are you willing to say that we'll drop our agenda as to vertical integration? If we find that common ownership by private equity firms across industries is not a problem of competition, are we willing to back off from that? And if you're committed to empiricism, what are your institutional commitments? I think Lina's absolutely right to talk about institutionalism here is important. And here's maybe where I would have common ground with the neo-Brandeisians. The Federal Trade Commission is designed to be an empirical organization. It's designed to find facts. It's designed to do market studies. It has coercive mandatory processes that no one else has for figuring out how markets are actually participating. So maybe a place that we could kind of agree on an agenda is just to really get more solid facts, authoritative facts about different markets and different kinds of competitive problems as a basis for decision making. And I think our pact needs to be that once we commit to that, we're going to follow the results and not a priori ideological ideas about what the outcomes should be. Thanks.
I'm sorry for a couple of things. First of all, I've been trying to find an online test to find out if I'm a neo-Brandeisian, and there isn't one. The second thing I'm going to apologize for is I'm from the University of Utah, and so I have learned things such as post-Keynesians, neo-Ricardians, neo-Marxists, and things that most people don't know because those were challenges to the Chicago school that died. So, or maybe they're still around, but I never hear about them outside of Utah and maybe the New School for Social Research. So my problem is I don't know what we're talking about. And so I'm going to give a top 5 list, and there's probably 20 more of things that I really wish, it's my holiday wish for the neo-Brandeisians that I wish they would gift wrap to me so that I could be happier and not feel like the guy begrudgingly hating consumer welfare. There's a reason I'm sitting next to him. And saying things like, get off my lawn. The first thing is, I want the Neo-Brandeisians to know that Casablanca was wrong. Do you remember the song in Casablanca? A kiss is just a kiss, a sigh is just a sigh. Well, it's not, and The Godfather taught us that, right? A kiss can be something that is deadly. I know it was you, Fredo. Is that the kiss of Neo-Brandeisians? Or is it like 50 First Dates where it's completely, completely forgettable, right? And I can't tell the difference because I don't know what we're talking about yet. I know what we're against if I'm going to be a Neo-Brandeisian. I know that we're against the consumer welfare standard. That's great. Mark Glick has shown it was misapplied in antitrust from general economic theory. And I have shown that it's been stolen from physics, even in the first instance. And if physicists knew how it was stolen, they would all become philosophy majors. Okay. Again, Neo-Brandeisians are against market power. That's great. Can we assert that there's under enforcement and also that the tools are not focusing on where they should be? There's another thing that's missing in that antitrust doesn't capture everything. Antitrust used to be taught with something called regulated industries. There were times when you could not cure things with an antitrust remedy and regulation had to step in. And when essential facilities went the way of open access, there was some recognition of that sometimes regulators would have to set up the rules of the game. And so I would hope that there would be a broader discussion of Neo-Brandeisian school of thought beyond just antitrust. I hear therefore empiricism, and that's great, but empiricism is not without theoretical framework. I've heard I should ask the Bayesians about that. Okay. So that's the first point. Second point, Santayana was right. Those who do not learn the lessons of history are doomed to repeat it. And the major lesson of history here is the Chicago School co-ops everything. Okay. And Dan has pointed this out. Okay. For decades, economists have said humans aren't rational. They aren't. Okay. And that was ignored by the Chicago School. And then all of a sudden we have behavioral economics, which is now the hip new trend in antitrust, apart from the Neo-Brandeisians. Maurice Stuckey's not here, right? Okay. All right. Guess what? That's been around for centuries too. Veblen, and one of his books, which I can't remember now because I'm getting old, says a gang of Aleutian Islanders slushing about in the rack and surf are in fact engaged in a calculus of wages, profits, and rent. He's making fun, right? So this is not new. The Kuhnian paradigm does not apply in antitrust, and more often than not, things get co-opted. Okay. And some of us have been saying for many decades the same things that Neo-Brandeisians are saying, right? And in fact, where did Keynes go? If you take an intermediate macroeconomics class, you see him a little bit in the ISLM model, right? Even Marx was co-opted by the Chicago School. Analytic Marxism was something that we'll switch the labor theory of value to the utility theory of value. So I fear for the Neo-Brandeisians, if they don't get more specific, they will be co-opted and therefore become meaningless. My third point, Battlestar Galactica. All this has happened before, and it will all happen again. So let's reflect on some of the more specific concerns. Predatory pricing. This is Tim's big concern. And Section 2 in general, which I know Lina would like to see revive and alive, and even become more, no pun intended, prime time. The paradigm adjusts, but doesn't give in. We now see predatory pricing as, as something that people in the economics realm recognize exists. We even see concerns about the disparity between the application of Section 2 versus Section 1 and how that leads to concentrations upstream and downstream. And the problem is that doesn't change courts. Even if you change theory, you don't change the courts. And all we have to do is look back at the substantial contributions of the post-Chicago School in the 90s to demonstrate that. Any post-Chicagoans here today? They were maybe as popular about the same amount of time as grunge was in the 90s. And that's it. That was their heyday. Fourth, I hear the grasshopper. I practice Kung Fu, so I can say this. In this TV show, A bold child pities a blind man, and he learns that the old man has some skills that the seeing child does not. And so the child learns a lesson in humility. For folks in the neo-Brandeisian school, I'm very proud of their ability to see the problems of antitrust, but I feel like the slavish devotion to Brandeis is taken out of context in many settings. The pendulum between being pro-antitrust and against antitrust swings back and forth. And so is this a movement that will last, or will it go away again? I don't know. By the way, even if you get Congress to listen, I have a great story for you. It's called the Tunney Act. Right? I'm cited in the congressional record. They changed the statute. Guess what happened? Nothing. You're welcome. Okay. So the courts, the DC Circuit, didn't actually listen to what Congress had said. Completely disregarded things. And so, and isn't that the point of legal realism, that judges can do what they want? My last point. And because I'm in Salt Lake City, how many of you have seen the movie Salt Lake City Punk? Thank you. One person. Oh, 4 people? Okay. You're a faster counter than I am. All right. I was up all night trying to find that test. Okay. So it says, and I don't mean any disrespect. I think all the people on this panel are friends of mine, and I really appreciate what they're doing. But one of the curmudgeons in Salt Lake City Punk is really mad because the what they call the posers are saying anarchy in the U.S., anarchy in the U.K. And they say, what's that? Anarchy in the U.K. What good is that to those of us in Utah, America? It was a Sex Pistols thing. They're British. We're not. Right? And that specific phrase had a particular meaning. And my problem with the neo-Brandeisian school thus far is the dangers of ambiguity and what the courts will do with that. And so far, the courts have had tools. They've known about the changes in predatory pricing economic theory, but guess what? Stare decisis does not necessarily parallel changes in economic theory. Predatory pricing is a great position, is a great example of that. Beyond that, what standard should I apply in Section 1 cases? Should more things be per se illegal? What should be illegal under Section 2? Should refusal to deal be broader? Predatory pricing, what are the presumptions? What is the price, when are prices below cost, right? Well, should we change the presumptions regarding recoupment? What case law does the school reject and why? What are the threshold matters in exclusive dealing? What are the areas of agreement? What are the areas of disagreement? Is this a unit of analysis problem? Are markets defined in too narrow a fashion, and therefore the harm is defined in too narrow a fashion? If it's broader, do we have enough tools in the antitrust division? I don't mean that in terms of personnel. To actually engage in that analysis? What are the remedies? If we're going to change the standards, I would really like to hear more about remedies. And I know for Microsoft that sometimes thinking about divestiture is a great remedy to talk about. My students love divestiture on exams. In reality, it's a big problem, right? And there's a question about what I call whack-a-mole. Whack-a-mole is the game you bang down the goal. If you bang down a problem with a company because they're too big now, do you create other problems? I'll just give you a couple of examples. Has anybody heard of the company AT&T? It was broken up, right? Okay, we can see the signs of that today. What does it mean to be against type 1 or type 2 errors? How does that implemented in the courts? If we engage in structural presumptions, are there defenses to that? Justifications, excuses? Will Congress change some of these standards later when a less favorable antitrust Congress comes into play, if that's possible? So to conclude, I have some problems, and a criticism of a deeply flawed institution or economic theory isn't enough to kill it. I know this because I work in academia. And you have to have some very concrete, precise standards. And if you don't, your movement dies. And I'm definitely concerned about that. Where will it die? In the courts. So my concern ultimately is this. The Neo-Brandeisian school is not quite there yet. It's not quite a school. There's no coherent body of work. There are a bunch of people doing great work, and I love reading anything anybody on this panel produces, except mine. But that's not a school yet. And I'm a little concerned that the indeterminacy that the Neo-Brandeisians accuse Chicago of is in fact a problem in their own school. Glass houses and stones, right? Thanks.
Thanks. Well, I guess I'm on the skeptic side of the table. I'm not sure whether that's warranted or not. I have to say, I approach this being sympathetic. I'm suspicious of corporate power. I'm suspicious of most of the direction of economic policy over the last 4 decades. And Sandeep's comment about the state defines the market, I want to have that tattooed in my forehead, but I couldn't get anyone to agree to do that. There's a lot here I'm very, very sympathetic with. But I share the comments of our last 2 speakers here that I have some very, very big questions. And just to put it most fundamentally, I'm not sure whether the argument here, and I'm saying this very much as a layperson approaching antitrust policy, antitrust law, whether the problem is that we're doing the wrong thing, or we aren't doing the right thing correctly. And just for a little background, I grew up reading Monopoly Capital. And for those of you who haven't heard of the book, Paul Baran, Paul Sweezy wrote that in 1966. The idea that Robert Bork is the origin of all evil, I kind of sympathetic to that, but this was before the day of Robert Bork. When I was growing up, if you wanted to buy a car, you got a GM, Ford, Chrysler, American Motors. That was it. Okay, in other words, it doesn't strike me. I don't doubt we have more concentration in many sectors in the economy today than we did, say, 50 years ago, but it doesn't strike me that's a whole new era. Okay, so that's just, again, I'm happy to blame Robert Bork for things, but I'm not sure that that really fits the story. Getting back to the point, and again, it might just be my confusion, but is the issue that we're doing the wrong thing in antitrust policy, we're listening to Robert Bork in Chicago School, or we're not doing the right thing correctly? And Sandeep, he actually quoted, I had taken a few sentences, he read 1 or 2 of them. First, retrospective analysis of corporate mergers have found they often lead to higher prices and markups, and they generally do not yield productive efficiencies and indeed have often produced inefficiencies. Second, research has found that dominant firms can use below-cost pricing to eliminate and discipline rivals and maintain or augment that power. Okay, so I grant that. Let's say that's true. I mean, again, I haven't gone through all the research, but I'm sure that's true in many cases. So then if we had Robert Bork here, wouldn't they agree that then they decided these cases wrongly? Now, again, maybe I'm misunderstanding it, but if you had a merger and it resulted in higher prices, then didn't you just mess up? Okay, so that's the story, again, I'm missing here. And again, I understand the argument that, courts will be biased in favor of large corporations. I've seen that in Washington for over a quarter century. They hire plenty of lobbyists, plenty of economists who will say what they want them to say. I understand that. But that doesn't mean that they're trying to do the wrong thing. They're trying to do the correct thing badly. It's a corruption of the process. So again, is it an issue that the process is being corrupted or that they're trying to do the wrong thing? And I'm just not clear on that. Tim and Lina, both here and in their papers, they talk about we should think of a process of competition rather than the immediate outcome. And again, that makes a great deal of sense, but again, I'm not sure that's a departure from what courts are currently doing, the way cases are currently being argued. And let me just give a few examples. And again, I'm saying this very much as a layperson. I'm sure my co-panelists are much more expert on these specific cases. But T-Mobile and Sprint, the merger. Okay, so T-Mobile is kind of the renegade in the cell industry, underpricing all the others. They want to merge with Sprint. Okay, will that lead to higher prices? Well, I don't think it's seriously contested that it will. You reduce it from 4 major competitors to 3. But what T-Mobile and Sprint are arguing is that, well, this is necessary to preserve their survival as effective competitors. I can't speak to whether that's true or not, but that is what they're saying. That seems to me to speak to the process of competition. Okay, so do we want, they're not, again, I haven't read all the briefs, obviously, but they're not contesting, as I understand it, that it could lead to higher prices in the short term. So if we're simply looking at higher prices, they're in the wrong game. But if you're talking about the the state of the market, state of competition, I should say, that seems to be what they're arguing. Another major case, Time Warner and AT&T. Okay, they're merging. I haven't followed whether that merger's gone through yet, but you know, there again, the argument, has it gone through yet? I'm
Do your homework a little
bit. Okay. Their argument as to allowing the merger was they have to merge in order to compete with larger competitors, with Apple and Amazon. Again, whether that's true or not, you know, was that merger necessary? I'm perfectly happy to believe it wasn't, but the point was they were arguing about the state of competition of the market. So again, I'm at a loss, you know, if we're saying that the focus has to be the market, the state of competition, that seems to me as a kind of outsider approaching this, that seems to be what they're arguing. So our Neo Brandeis is saying something different, perhaps, but I'm not sure what that is. Another example, we've had enormous consolidation in the airline industry. Okay, and as the airlines consolidated, they were arguing that we need more market power, more pricing power in order to stay in the market. And I have to say, again, as someone who doesn't do this as their main area, that seemed outwardly credible. Airlines were going bankrupt with a considerable degree of frequency. If you take the 5 years from 2001 to 2006, they lost an average of $10 billion a year. So that doesn't seem like a far-fetched argument, but again, whether that's right or wrong, the nature of the argument was that we need these mergers in order to have a stable industry where you have stable competitors. So again, you could argue that was a true claim, false claim, but it seemed to be a claim that was based about the state of competition in the industry. Okay, so I'll just say, I'm confused on that. I'm not making any attack on my co-panelists who are all, you know, very prolific writers and have contributed a lot, but I'm just unclear, and I'll just say that. The political power point, again, I'm sympathetic to the idea, we see it all the time, where you have large corporations get their way for no good reason except that they're large corporations. But I have it reminded to me endlessly that it's not just large corporations that are able to get their way. And let me just give you two very prominent examples. One, if you go back to the 1970s, the savings and loans, most of the savings and loans in countries were bankrupt by any standard measure. Okay, that wasn't really a debatable point. It was widely known at the time. They should have been shut down. I won't go through all the logic of banking and why you don't want banks to be running and staying in existence when they're not solvent. But in any case, they were allowed to stay in existence when they weren't solvent. And what happened? Well, they ran up huge losses, and we ended up with a much bigger cost associated with the savings and loan bailout than would have been the case if we had them shut down in the late 70s when most of them were insolvent. Well, why did that happen? Well, they had enormous political power. Were they big? If you take the very biggest of the savings and loan, it would be dwarfed by a mid-sized bank today. Okay, so they were able to have very significant political power in spite of having a large number, having small savings and loan acting collectively. To take a more recent example, 2010, we had the Dodd-Frank bill with the Consumer Financial Protection Bureau. Okay, well, who got exempted from the Consumer Financial Protection Bureau? Anyone know that one offhand?
Car dealers.
Car dealers. Car dealers? Well, it's relative. I mean, there's been some consolidation in the industry, but in the scheme of things, I haven't looked at the measures, but I'm willing to bet that car dealers are a relatively non-concentrated industry. Why'd that happen? They were, you know, car dealers in every constituency, and it turned out one of the powerful members of Congress happened to be a car dealer. They got that through. Okay, so this was something that made no sense. I mean, you know, I saw that, you know, maybe someone will tell me otherwise, but I don't think you could come up with a plausible story as to why car dealers should have been exempted from the regulation there. So again, I'm not saying that bigness doesn't often convey power. I'm just saying it's not, might not be as simple a story as just saying a big corporation has a lot of power. If we have lots of small corporations, we don't have to worry about that. So just think it's a little more complicated than that. And again, I don't want to attribute that view to any of my co-panelists. I'm just saying, you know, something we have to be cautious about. Taking an issue, you know, that's been in the news lately, Facebook. Everyone is concerned about Facebook's influence on our politics, on our elections, and they've said they have a policy. If I run for office, I could lie about everyone here. They're going to let me do that. Okay, well, you could say, well, this is a problem of bigness. Facebook has, you know, this near monopoly on social media, or at least a category of social media. Okay, but what if libel laws, the same libel laws applied to Facebook as applied to other publishers, you know, to newspapers, to broadcast outlets? Well, they could be sued for conveying information, conveying statements that they knew to be false. Okay, so is that a monopoly issue, or is that an issue of libel law? And again, you could argue what we want for libel law, but to me that seems like that's an issue of libel law, not one that's monopoly per se. So these, I'm just saying that sometimes I think we could overstate what we see as the problem of bigness, the problem of excessive monopoly. Now, having said that, I think there's, undoubtedly failures. I mean, I don't think, if we look back at the history of how Microsoft got a near monopoly in the operating systems market, I don't think anyone could look at that and, well, maybe someone could look at it. I can't look at that and go, oh yeah, that makes perfect sense. I mean, I remember I came to Washington in the early 90s, I was talking to a reporter, she said, what do you think about this case where Microsoft, this was like 91, 92, they had contracts with the major computer manufacturers at the time, Compaq, Hewlett Packard. They had contracts where they would pay Microsoft for every computer they shipped, whether or not they used their systems. And I remember when I heard this, I go, that can't be true. That's like classic antitrust. This is supposedly what Rockefeller did, that the rail companies would pay him for every barrel of a competitor's oil they shipped. How could they? Turned out that was true. And the Justice Department launched an investigation into it, and they settled. Microsoft agreed to stop doing it after they had 90% of the operating systems market. And, so I look to that and say, okay, that's a serious failure. Now, I don't know if we need to be a neo-Brandeisian to say that, but that looks to me like a clear failure. Google and Facebook, they buy up their competitors. Facebook buys up Instagram. I don't even know there's an investigation into that, and it was openly said. I mean, it wasn't a secret. That was to eliminate a potential competitor. You didn't need the neo-Brandeisians. I mean, they might have said that, but, you could pick up the business press, they said that. So there have clearly been major failures, at least to my view, in allowing for the consolidation of, at least in certain sectors of the economy. And I think, I'll just say as someone who's agnostic about whether I want to join up with the neo-Brandeisians, I'd say, yes, these were very, very serious failures. We've had enormous consolidation and monopolization in some major sectors of the economy. But the question I'd have is, I don't know if that means you have to have a different philosophy or just say, we should have been applying the philosophy we had all along. So I guess that's the question I'd have. Thanks.
All right, well, thanks everyone. I have been noticing Lina and Sandeep furiously taking notes throughout these criticisms, so I'm going to give them a chance to respond, and then we'll have some discussion, or I guess this is the discussion.
Great. Well, I first want to just thank everybody for the really thoughtful contributions. I think this conversation is definitely surfacing a lot of really important questions. And yeah, it's really a gift for I think those of us who identify as new Brandeisians to be kind of subject to this rigor and these questions. I was a little struck by the conversation. It seemed to me that it resembles, in crude terms, how antitrust enforcers are talking when assessing whether there is a viable nascent competitor in the market. And I think the key question right now is, the degree to which New Brandeis will and can emerge as that competitor, or whether it should in fact be assumed by post-Chicago, which will be able to, actualize on its promise more effectively. I guess just a couple points I wanted to touch on. It seemed like, a key thread throughout is that there is a robust commitment to empiricism, and I think an openness and a welcoming of empiricism that is perhaps identifying some of the flawed assumptions that have been embedded in theory, in the antitrust doctrine in theory for the last few decades. I think a key question, though, is what is the role that economics and empirics is playing? And I think this is a question that Tim takes up in his Curse of Bigness, where he says, economics should inform antitrust, but it should not be decisive. And I think one reason I would share that view is because I think there are limits to empirics in economics, and I think, the way that Dan frame the question is what happens when your anti-dominance values are in tension with where the empirics are taking you, and I think that's an important scenario to consider, and I imagine people would come out perhaps in different places. But I also think we need to talk about what the limits of empirics are, and I can imagine at least a couple of scenarios. One is what I think of Justice Breyer sharing in the Legion argument, where one of the advocates in the Legion argument kept talking about how there was now economic consensus around this issue of retail price maintenance. And Justice Brandeis goes, but we have economists that are also filing amicus briefs on the other side. Are we supposed to count economists? And I think it really shed light on this question where, on this issue, which is that there's empirics on all sides of these questions, and antitrust economists are very well compensated for this reason. And so I think we need to be thinking about, what do we do when the economics is not decisive because there is a debate? And are judges really the best arbiters of what economics should be decisive? The other question, I think, gets to the issue of hubris that Tim was raising, that it really is quite ambitious to expect that empirics and welfare economics in particular will be able to measure all the things that we think antitrust should care about, let alone all the things that we care about, even if we don't think that antitrust should encompass them. And so I think, part of this question is should the role of economics and empirics be, and what do we do when there are very clear limits of that?
Sandeep.
Sure, so I'll respond to 4 points principally. So I think the neo-Brandeisian movement has to be situated within larger trends in our society. It's not something that is isolated. We're not living in a world where people are generally happy with the status quo, but there's a lot of sort of discontent with antitrust. It's obviously much broader than that. So there's discontent and growing disillusionment with dominant modes of thinking, whether it's in antitrust, whether it's in labor law, whether it's in political economy more broadly. So I don't think we should see this as an isolated movement. It's something that is part of something deeper. You could call it a reaction against neoliberalism. And you can look at the democratic debate that's ongoing and compare it to the terms of debate in 2008. And it's radically different. And even on the Republican side, the rise of Donald Trump, albeit in some strange forms, captures discontent with neoliberalism, for instance, in the context of trade policy. So this is not something isolated on its own. So that gives me a little bit of hope going forward. But all that said, there's a tremendous amount of work to be done. I think we're very much in the early stages, and there's a lot of movement building, organizing, and frankly just hard thinking that hasn't been done yet. So second, I think clear articulation of goals is really critical for this movement going forward. And I would point to, once again, the legislative histories of these laws. I think they capture a broad understanding of corporate power and sought to restrict the power of the trusts and monopolies over consumers and sellers, preserve relatively open markets to worthy men and small dealers, to use a line from the late 19th century Supreme Court, and third, to generally limit the political power of large corporations. But I think articulating and honestly just repeating these goals are essential. I think one of the big shortcomings of post-war antitrust was goals were not always clearly articulated, and in the same line of cases, you'd have one case talking about consumer effects, then another case talking about effects on small businesses, then another case talking about general concerns about political power of big business. I'm thinking specifically of the merger decisions of the 1960s with a case like Philadelphia National Bank emphasizing the consumerist aspects of merger law, then Brown Shoe talking about the general harms of concentration, and then Vaughn's Grossi focusing on another theme. And I think the Chicago School has been extraordinarily good at hammering home when it's about consumer welfare, higher prices, reduced output. Every Chicago School opinion will use some language in that form. And if we are to experience similar success, I think we need to clearly articulate and just repeat our objectives. Third, I think there's an ongoing debate about rules versus standards in antitrust. I think neo-Brandeisians clearly fall on the side of rules. We need per se rules, presumptions, instead of trying to undertake this complicated cost-benefit analysis that, frankly, even under the consumer welfare standard is simply infeasible. Once we bring in a broader set of goals, the intellectual challenge only becomes more severe. And I think this is where empirics come in. Once we have a set of goals, the question is, where do we draw the line on mergers? What do we define as predatory pricing? And I think empirical research can really aid us in setting precise lines. But as Lina said, it's no substitute for goal setting. There's no possibility of simply looking at the data and having an aha moment and realizing, yes, the correct answer is 42. That's really not how empirical analysis works in general. And the last point I want to make is institutional. Antitrust is a little bit of an outlier in modern federal law in that it's still made by courts in a common law process. And if you compare it to, let's say, consumer protection or labor law, where agencies and Congress have actually written detailed statutes and regulations, antitrust appears really weird, almost a throwback to the 19th century. And I think part of the new Brandeisian movement's goals are to shift power away from the courts, away from the least democratic branch of government, back to regulators and ultimately Congress, so that bodies that answer to the public in one way or another are setting goals and making the hard decisions instead of having judges operating in isolation, deciding cases based on sort of the theory du jour. So those are the 4 points I wanted to make.
All right, thanks. So I think one of the great successes of the Chicago School was that it had, as we said, kind of an overarching philosophy, and but then, as everyone discussed, got down to specifics, what it thought on a range of areas. And I won't repeat them all, but vertical things are never a problem. Only merger, let's exaggerate a little bit, the only merger that really you want to be concerned about is merger monopoly. There's a couple of sort of guidelines. And I think what we need, based on in responding to comments, is we need to outline our areas and what we think of them. And they're kind of a jumble, but let me discuss what I think are, say, the 8 leading areas where I think that there is a clear sort of neo-Brandisian view on what should be going on here. So let me start with one. One, I think, is that we think that labor markets have been neglected and that there's been far too little, just at the basic line of scrutiny and investigation of abuses in labor markets. As Lina has documented well, many of us believe the predatory pricing cases should be overruled. That's shared by the post-Chicagoans, who are still around, by the way. I was at the University of Pennsylvania conference 2 weeks ago of the Chicago, of the post Chicagoans, and they're very active. I think most of us think Trinco immunity should be overruled. I think many of us, I don't know most, believe that there should be many more antitrust rulemakings along the lines of the eyeglass rule as a good example in the 1970s, probably through the FTC. I think most of us believe that there should be more structural remedies, that behavioral remedies have been unsuccessful, and the structural remedies have a better track record. I at least believe, and maybe others believe, that Noor-Pennington should be overruled, replaced with the First Amendment defense. I believe, and I think many other people believe, that there needs to be much more Section 2 analysis of a pattern of mergers. You mentioned the Instagram, which is actually subject to an investigation by New York State and 46 other AGs who, there's some New York State enforcers here. But we need a practice and a pattern of retroactive merger analysis. We've no way of looking at stuff that already happened. When we're sure we made a mistake, there's no reset button to undo it, or we need to develop that. I think that neo-Brandisians believe in a revival of the relevance of intent evidence over merely pricing evidence. That in a lot of areas we think that if you discover good evidence of anti-competitive intent, that should be itself presumptively proof of harm. If they thought they were harming people, then they were, or then that's enough to have that be a problem. And I probably missed a few, but I think these are the specifics, and this is what we're developing. We're not there yet. I won't deny it. The fact that some of our panelists can't seem to figure out what we think is a problem, or can't figure out how AT&T Time Warner went is a problem. So we need to we need to do a better job of outlining these, and we may not all agree on all this. I may have made a list. I don't know if my co-panelists actually agree with this, but this is what is crucial to the success of this, is having our 8 or 10 kind of areas where we believe. Can I just say one last thing in response to Dan's comments? There is, I think, a difference between a Brandisian political theory and neo-Brandisian antitrust. When I looked at the neo-Brandisians of the Second New Deal, they weren't, even though he was still alive, they weren't always 100% in line with what Brandeis would have wanted. I personally am a Brandisian, so I personally agree with that government getting too big is a problem as well. I believe that any mature political philosophy has to accept trade-offs, including efficiency losses, for what it does. And I agree with and wholly endorse the sort of easy point that empiricism, but I don't only mean research into price effects, but deep studies into what really went on. This is what Brandeis liked when he fought the Hartford Railroad. He got into it and tried to figure out exactly what had been going on behind the scenes. This is a little bit about the intent evidence I was talking about, a little bit more the way civil and criminal investigation goes. I believe in that as well. So I'm willing to go all the way down the line, but I don't think that my convictions, you have to share all my convictions about Brandisian political theory to be part of the neo-Brandisian antitrust movement. So that's what I'd say.
Yeah, go ahead.
So I want to make a challenge to my three colleagues here, which we have three of the leading voices on neo-Brandeis. And Sandeep has told us it's important for neo-Brandeisians to articulate the goals. So before you leave this conference, can you come up with the Utah statement on what are the goals of the neo-Brandeisians? And I don't mean the laundry list of things Tim's talking about, which are the policy implementation of those goals. I'm talking about something elegant and operationalizable, like consumer welfare, right? We could still debate what it means, we could still debate what it leads us to, but can you tell us, can you three agree on what that principle is that neo-Brandeisianism will have us to do? And again, it's important that it not just be something vague and aspirational, but something that we could then start talking about, well, where does that lead us in terms of predatory pricing or vertical mergers or anything else? Because if the three of you can't agree on that, then I really don't know where we are.
So I probably came off a little harsh, but it's kind of the tough love that Mark Glick gave on my dissertation. He scratched off long lines of pages and said, stop wasting time. And so I'm very sympathetic to the movement, but I'm also very careful about the recoil that's going to happen with any movement. So for example, you're thinking about an agency model and how that could take away from the courts. Well, I think you should take a look at what's happening with the National Labor Relations Board right now, all right? Not all of the commissioners or board members are there, and because the statute was so poorly written, there is some anti-labor movement within the board because of the way the board dynamics are structured. I also want to caution you about using the legislative history too much. And it's kind of like the whole discussion about constitutional debate about the Second Amendment, whether muskets should be around or not. Because it really wasn't a commodity-based economy when the legislative history was drafted. And so I'm questioning whether or not you're going to get a counterattack about whether that's at all meaningful given the economy we have now. Even the FTC legislative history, which I've argued says that the FTC should be the one true enforcement agency. Should we have an Uber regulator? Well, it's nice to say that now because the FTC is actually doing some work as opposed to the DOJ, which is doing nothing. But that's not always been the case, right? And so the pendulum swings again. The other thing I want to caution you about is the capacity of an agency to ignore law. And I've mentioned that with respect to the Tunney Act, but I pose this question to you. Is Philadelphia National Bank still good law? Because there is some discussion out there about the out-of-market efficiencies that are in the merger guidelines. And Philadelphia National Bank eschews that. And so if you give too much power to an administrative agency, right, you tend to insulate it and also allow for it to be attacked from political insiders. So I have that fear. And by the way, labor markets weren't always neglected in antitrust. And so, in fact, some of the first cases were against labor unions, right? And so I'm not sure bringing attention to labor markets won't necessarily lead to bad outcomes. I'm a little concerned about that. And finally, I want to say I am very glad that two other things actually. One is You mentioned Nora Pennington. I think a bigger problem is Citizens United. And whether or not, and that seems to be out of the framework of antitrust law, but really it isn't. And of course, Spencer Waller's done some has some discussion about antitrust and democracy. And my final point is I'm very glad that you found a post-Chicagoan preserve for endangered species.
I have a question I wanted to pose to Tim and also to Darren, but anyone should feel free to weigh in. I mean, you expressed some trepidation about institution building and movement momentum going forward from here, and I'd frankly be seeking your advice or thoughts about how to ensure that those bad outcomes don't come to take place. And in particular, I want to address this question of empiricism and antitrust because and its capacity to be co-opted, which I think both Lina and Darren were at least referring to. I've heard Josh Wright, for example, refer to the Chicago Revolution and antitrust as an empirical revolution, which I think is, historically, not correct.
That's
But
the biggest bullshit I've heard recently.
yeah, but it speaks to the question that economics was brought into antitrust and economics is empirical and therefore the Chicago Revolution is empirical. Like these are sort of more than substance. They are totems that can be repeated and thus kind of denuded of any of their power. So I wonder how can in general a movement be built, but also in the specific case of the role of empiricism and antitrust, like how can that kind of retain the edge that it has now or had previously without just being said like, oh yeah, that's what we're doing. That's what happens whenever you get two economists arguing against each other in depositions.
Since we're throwing things that are neo-Brandeisians, can I just throw in one quick question? Because a serious question. The issue of the Instagram-Facebook merger that, as you point out, is now being questioned, but of course was not originally. Could one just be a straight consumer welfare person and say, on consumer welfare grounds, this merger shouldn't have taken? In other words, do you need a different philosophy, or could we just have said, based on the consumer welfare grounds, it should have taken place?
I mean, this is part of what, actually, you're quick. Can I just stick with that question? This reveals something really important that Lina talked about, which is to say, some of what neo-Brandisian ambition is, and as Dan's challenged us to have it, is to have a different position on things. But that, and therefore say, well, we're going to challenge these mergers. But that doesn't, if you happen to challenge, if you have an easy price, let's say Sprint T-Mobile. I'm a neo-Brandisian. I think we should have challenged Sprint T-Mobile. The easiest way to demonstrate it's harmful is higher prices. That's not like some big problem. I think you got to stop mergers that are bad mergers. And if you argue to the court the most straightforward, easiest argument, it doesn't mean you've betrayed your cause. And I think that's a really important point. You don't have to. The neo-Brandisian school, to be successful, doesn't have to ignore price effects in every case in some kind of way.
Can I ask you?
In fact, I don't know why you would do that.
Can I ask you a follow-up question?
Well, let me answer. I think there's the first. Oh, you want to go for it?
Yeah, this is in relation to what you just said, though.
Yeah.
If you're focused on empiricism, are you in fact rejecting the incipiency standard?
Am I? No. You mean in Section 7 cases? Am I rejecting? Why would I reject the incipiency standard? Because you think you can't predict things? Is that what you want to say? Or because you're? I think it's kind of a technical question. No, I don't reject the incipiency standard. That's how I think you should have stopped the Time Warner AT&T merger, among other things, is that it was likely to lead to a consolidation of the industry in its incipiency. I do often think, though, that if you're compared to, I wouldn't reject it. I think in merger review, you're often in a better position empirically in a retroactive stance. And that's been my argument in the Facebook case, is that, the agencies and the system of antitrust needs a way to look back when things become clear as to the effects of a merger, as you were talking about, or the effects of a pattern of mergers, which might be invisible on a merger-by-merger basis, and then have the capacity to do something about it, undoing the mergers that were made up the thing. That's why they did in Standard Oil. Standard Oil was litigated way after the anti-competitive acquisition campaigns, and I think it's something we need to bring back. But let me answer your question. Somehow we got a little bit on a tangent there. Can you remind me your question? What do we need to do, right?
How do you institutionalize, and build on excitement and not allow it to dissipate as you sort of forecast?
No, I think that's a really important question. That is kind of the question of this panels. So I think I would say you need three things, three areas of institutionalization that are extremely important. First, and sort of the easiest, is there needs to be a strong academic presence committed to doing the work on these things that I've talked about and outlining different approaches. Whether they call themselves revivalism, I use revivalism sometimes because I want to include some of my friends in, let's say, the Thurmond Arnold model, who are also challenging things, but they're not into Brandeis. I mean, like I said, we don't want to kill each other over whether you like Brandeis or Taft better, or that's a dangerous tendency for antitrust revival. So part of it is the academic work. Part of it is the work of changing the laws and changing the standards, and that is a much more applied undertaking. It's a long time. And it involves getting people into government who believe in some of the values which we're about to put together later in this time. And the third and final thing, and I think this is really important, is targeting the judiciary and understanding that lasting change does come when the judiciary begins to move and become persuaded and understand the arguments here. And I think this area has been a non-priority for judicial appointments for a very long time. It's kind of, civil rights are a priority, even abortion, other things, but almost economics in general, but in particular antitrust, has been completely left out of the formulation as to when you appoint a judge or not. And I think that is a big problem and needs to be rectified.
I would just add a
Lina would
fourth to the
probably
third,
have
which
three more
is
if you want,
that, right now there's a tremendous amount of energy among law students in particular in antitrust and in thinking about how do we create an antitrust that is actually addressing the problems that we're encountering. And I think figuring out how to harness a lot of that energy, I think there are right now a lot of shortcomings in terms of, where in government should somebody go if they want to be a progressive antitrust lawyer, where they think they can do that kind of work. What are the gatekeepers in academia that are potentially going to hamper, their success if they go that route. And so figuring out, how to institutionalize in the way that Chicago very successfully was able to institutionalize and channel that student interest is also something that I think is going to be an important task ahead.
Can I add something that's been a personal focus of mine, which is not neglecting the states? I think a big mistake that a lot of reformers make is they're like, well, okay, we'll get this once we convince these three, the Senate Democratic leadership or something, and that's the whole debate. The states are taking front stage in antitrust revival right now. They're the one who's bringing the case against Smith Noble. It's not the sitting on their hands Justice Department. It's definitely not the FCC. It is the states, and that's a very, talk about how consistent you are with Brandeis. Brandeis, as everybody knows, thought the states were the place to experiment with economic policy and doing things different. And I think I guess I couldn't say it more. I think we need to understand the states' role in keeping the antitrust project alive. Actually, it was the states who sued Standard Oil before the federal government, Minnesota particularly. And that has been neglected by generations of reformers who think it's all about, being a step. I know you're a staffer in Washington, but I think it's all about, how do we get Washington to change its mind?
So I have a bunch of notes here, not in any coherent order, but want to respond to a couple of points. To build on what Lina and Tim were saying, I think it's really critical that we have, to paraphrase Richard Hofstadter, antitrust prosecutions with an antitrust movement. We've never really had those two at the same time. So we had an antitrust movement in the late 19th century that didn't actually achieve much in terms of restructuring the economy, and then in the mid-20th century we had a deeply technocratic antitrust that did a lot, but there's basically no popular constituency for antitrust. So moving forward, it's really critical that we engage the public on this and view it as a part of a progressive, populist political economy. I'm not expecting average non-specialists to be reading the horizontal merger guidelines, but I think it's critical to show the public that this actually has value and materially makes their lives better. And I think in the near term, just showing that antitrust makes a difference, gives people more freedom, gives people more income, I think that really has to be the basis of a durable antitrust movement in this country.
I do want to open, oh, sorry, go ahead.
One
Yeah.
other point
Oh, wait.
that, and I think I disagree a little bit with Tim here, is on the equivalence between big government and big business. For one thing, I'm not entirely sure what big government means. It's sort of a slippery term. So someone might criticize big government and say that the FTC imposed some modest limitations on corporate prerogatives, and at the same time turn a blind eye to the fact that the Department of Defense sucks up about $700 billion every year. So I'm not sure there's really a stable, coherent definition. And on top of that, there's an important distinction between concentrated private power and concentrated public power. Concentrated public power faces some, albeit imperfect, accountability through elections, whereas concentrated private power faces no real checks in the marketplace and is not subject to popular accountability. So to put it bluntly, we have the opportunity to elect out Donald Trump in about a year's time. We'll never have such an opportunity with Mark Zuckerberg.
I think that's quite apt. I want to give the audience a chance to ask some questions. So if you have any questions, please let that be known. I don't know if we have a microphone for the people in the audience. You want to go here and then to you?
Start at the back.
Okay.
Thanks. I just have a question. I think one of the gentlemen in the middle, I'm far enough away that I can't quite tell who's who there. I can't read the name tags. Asked the neo-Brandeisians if they would follow the facts, say if it turned out that private equity buys all these firms and does absolutely nothing about their competitive conditions. Now, I'm not aware of studies that are good on private equity, but there are excellent studies already of the coordination investment mutual funds have been doing. George Schmaltz and others, Schmaltz has a terrific OECD memoir on this point that I think is really quite good and quite decisive. And it's obvious that the European Union regulators recognize this. American regulators don't. It's a problem. And I think it's true that this is a form of concentration that folks have not paid attention to much in the United States. I'm going to talk a bit more about that tomorrow. But I think the evidence is already in. And here the problem is to get the economists and lawyers in the United States up to the state of the empirical evidence.
I could speak to that, but you want to? Yeah, so I think that the evidence on common ownership, this idea that shareholders who own an overlapping set of companies in a given industry can coordinate those companies to behave in ways that are anti-competitive and in the shareholders' interest, has been one of the most active areas of research in recent years. And I agree with your characterization that research has come to fairly decisive set of conclusions about the anti-competitive effects at issue here. I would, if I had to say why that has not had the effect on policy in the United States, or that it might otherwise warrant, that kind of goes against two different tenets of, or I should say, the philosophy governing antitrust, as we've been discussing, is consumer welfare approach that favors consolidation in general as being beneficial to consumers if it leads to efficiencies, but also the idea of the concentrated power within corporations and between shareholders and management of those corporations is also benefiting the public interest by ensuring that the corporations are run in the interest of their shareholders. Is effectively the operating principle there. That's a different, but in my view, related tendency within the kind of economic theory, the intellectual history within economics, and the common ownership studies really bring both into question, in my opinion. So I think that kind of speaks to some of what's been discussed on this panel, that we need to understand that antitrust plays an important role, but not the only role in terms of regulating the concentration of power. Corporate governance that has permitted the operation of powerful companies in the sole interests of their shareholders and executives who are, in effect, solely answerable to those shareholders, has had dire consequences for lots of economic outcomes, as that literature shows. And that issue of regulating corporate governance, regulating the power relations within corporations, has not typically been the sole focus or a focus in antitrust, but it's nonetheless important to any kind of anti-monopolist or power deconcentration type policy agenda.
Thanks. I want to ask about antitrust and democracy. Sorry to the economists on the panel, although you may care about this too. So Tim brought up Robert Jackson, and I think Jackson, before he was Attorney General, before he was a justice, wrote about antitrust that we must not let private corporations become private governments. And Dan, you have a colleague at the University of Michigan, Elizabeth Anderson, a philosopher, who's written a book, Private Government, about the ways in which many employers rule their employees' lives. We might be concerned about other areas too, as Dean mentioned, Facebook's control over political speech and so on. So I guess I'd like to hear from Dan and Sandeep about this. Dan, is antitrust the right tool to address the threat of private government? And if not, why not? Dan, I'd also like to hear from you. You've written about technocracy and democracy and antitrust, and one of the justifications you've given for technocracy and antitrust was agreement about the ultimate goal or the ultimate value. If there's new contests over that goal, should it be more democratic rather than technocratic? And then Sandeep, if you can convince your the other people up on the panel with you that one of the goals of the revivalist movement should be public rather than private government, what would that look like in practice? Does that mean the analysis of market power should just not be about the extent of power, but the nature of power? How would that sort of work? What would that look like practically?
So thanks, that's a great question, and I could go on a long time. We don't have a long time. So I want to just second something that Lina said, which is there may be a difference between values and how we operationalize things. So one of my current research projects right now, which Tim and Lina have both been involved in, is about democracy and monopoly. I've been focusing a lot on mid-20th century fascism, and I have a couple papers about the way in which extremely concentrated power in Weimar Germany contributed to the rise of Nazism. Really interesting set of questions about that and the role of the U.S. authorities in trying to break up and why that failed, because the army, of course, wasn't a democratic government and didn't particularly value the democratizing influence of decartelization. But one of the things about that is you could come away, as I do, believing very much that extremely concentrated economic power tends to facilitate extremely concentrated political power. In the rise of fascism, the story is quite clear. But not be comfortable with making sort of democratizing markets an express goal of antitrust law, right? I think in my view, a focus on maintaining an economy that is economically efficient and produces consumer welfare has the beneficial effect of also preserving an economy that is deconcentrated. And so whether we should write that into a statute or into the way we actually go about enforcing the antitrust laws, I'm skeptical. I think that leads to certain kinds of abuses. At the same time, if you ask me, do I think that antitrust law is an important instrument of democracy, like political democracy, I think it actually is and should be.
So I think there's going to be one point of agreement between Dan and me. I think evidence and theory show that there is an association between corporate size and corporate concentration on the one hand and corporate political power on the other. So a larger corporation has more resources to devote to campaign donations and other forms of changing politicians and regulators' decision-making and also influencing public debate. And similarly, Mansur Olson's Logic of Collective Action submits that it's easier for a monopoly, certainly, or even a 3 or 4 firm oligopoly to organize to advance its political interests than it is for a market comprised of 20 or 25 firms. So I think there is a connection between preserving decentralization in the marketplace and democracy, in that you are weakening the ability of corporations to organize and act on behalf of their own private interests at the expense of the public. Do I think there's a strict one-to-one correspondence between the two? I don't think there is. But I think promoting decentralization, whether it's through stronger merger policy or stronger enforcement of Section 2 of the Sherman Act, will in the long run promote a stronger, more robust democratic political system.
Yeah, I would push back a little bit on something that Dan said, which is, if we care about the sort of political power deconcentration content of antitrust, it strikes me that you really can't, at least the empirical record is such that you can't stand on the consumer welfare standard as it's been enforced in the last 40 years. I mean, that, in some theoretical sense, you could say like, okay, well, the policy that maximizes consumer welfare is also happens to be the policy that gives rise to deconcentrated political power, and therefore we should have a policy that maximizes consumer welfare. But we don't have a policy that maximizes consumer welfare. We have a policy that says it's about consumer welfare that has led to the concentration of power in all manner of economic and political contexts all over the economy.
So I think this afternoon's panel will probably tackle the empirical question of whether we have an economy that's grossly, excessively concentrated in the way that's been assumed. I'm not convinced. I refer you to a recent paper by C. and Rossi Handberg, just published a few months ago, that empirically makes the claim that, in fact, the economy is not overall become more concentrated across all sectors, that to the extent it has become concentrated in services and retail, it's mostly because of local market entry by big players, and that is not caused by entry barriers or lack of competition, but instead it's caused by information technology improvements, right? Now, that could be right, that could be wrong. I'm not an empirical economist. I think that's this afternoon's topic. But I just don't want to leave on the table the assumption as unchallenged that we, in fact, and it's not that, by the way, it's not that we don't have a problem of competition in some markets. I'm perfectly happy to endorse the possibility that, say, in airlines or in oil, we've allowed mergers to happen that we shouldn't have. That's a very different question, though, to what I think is the narrative that's been presented, which is we have an across-the-board problem of concentration. I mean, Dean mentioned the car industry, which isn't what I follow. If you look at the car industry, during the heyday of vigorous antitrust enforcement, you had 3 choices. Today, you have about 15 to 20 major choices. Real prices have fallen. Rates of innovation are going way up, and we have dramatic new entry by companies like Tesla, Rivian, Faraday Future, and others. So I think it's very hard to sustain the argument that across the board, competition has failed our economy.
All right, well, we will indeed be returning to that this afternoon. In the meantime, are there any more questions for this panel? Yeah.
Speak loudly. I'm a reporter with NLEX, and I just was curious about, so there's at least four different investigations going on at the federal agencies, Congress, states. There's this shift in theory from consumer welfare standard to the new Brandeis school. How is that impacting these investigations? Is it hamstringing them? Is there too much disagreement? What will is it too early to tell? I mean, they're all very early on.
Well, none of us here are, Lina's the government, but we're not in, should I take this question? We're not, actually inside the agencies. But I am a big believer, having studied the intellectual history of these movements, that the change, the sort of shift, the feeling that there's something in the air, whether it's antitrust revivalism, neo-Brandisian, it's the good work of places like this university and the Roosevelt Institute, a lot of civil society groups, OMI, has put something in the air, has made, I think, attorneys less fearful, more courageous. I think a lot of this does come down to the willingness to act inside the agencies, and whether they find 1,000 different reasons that they really better not do this, or whether they think like, maybe this walks like an abusive monopoly and talks like an abusive monopoly, so I better at least investigate it. And maybe this case where Facebook bot seemed to buy up its major competitors is a Section 2 case hiding in plain sight that no one's done anything about. I think that is the influence of these kind of movements, is it gives attorneys, gives people inside the courage of their convictions. Because you go into an enforcement agency, obviously don't want to do anything, but you want to bring cases that look like violations of the law, and people see a lot of stuff that they're troubled by. I've been in enforcement as well. But then they get scared off by the 1,001 reasons. Maybe Congress will annoy us. Maybe this will backfire. Maybe this, maybe that. Will I be seen as some kind of wild figure for doing this? And I think the great contribution that we're making here is, as I said, to give the enforcement agencies the courage of their convictions to start bringing some big cases.
I guess I would just add that I think journalism has also played a really important role in like constantly documenting the kinds of problems that we're seeing. I think, 2 years ago, especially right after the Amazon piece, a question I would always get would be like, what is the actual harm here? You're talking about Amazon's power, but if you surveyed antitrust attorneys, nobody would raise their hand to say, yes, we think there is a basis for an antitrust investigation to Amazon. And, fast forward 2 years, and there is now, multiple investigations basically on the same set of facts. And if you think about what's changed over that period, in part, I think it is what Tim mentioned, this outside set of civil society groups and nonprofits that have been kind of, banging the drum on this. But there's also been really good storytelling documenting what are the various kinds of harms that have make it more difficult, both for lawmakers, but also enforcers to ignore that there are serious problems here.
Oh, yeah, sorry, Sandeep.
So I've been thinking about something Dean said earlier. Dean said that if Robert Bork were confronted with the evidence on predatory pricing or mergers, he would reevaluate his views and call for stronger antitrust doctrine. Putting aside
Let me say, someone who adhered to his philosophy. I don't want to give Bork
I don't want
credit
this
for
to be
credibility, integrity.
about one individual. But if you look at the antitrust agencies, and Marshall can attest to this because he's produced some of the cutting edge empirical research here, is there's almost an aggressive anti-empiricism. So there's a growing body of research contradicting the conventional wisdom on mergers, and I talked about it earlier. John Koka's work is probably the leading example, but there are a number of papers now. I think we're close to reaching a critical mass. And instead of sort of taking this evidence and saying, maybe we should revisit the horizontal merger guidelines, establish presumptions at a lower market share or lower market concentration, the agency's response has been to either ignore the evidence or disparage the evidence and find like methodological quibbles with particular studies instead of saying, there's actually a lot of work out there now. It's not just 1 or 2 studies, it's many more than that. And I think the response to a lot of the labor market monopsony research has been similar, a gap based on your conversation there.
Yes, yeah, no, I mean, there's definitely a kind of a sort of like zeroing in on one supposed flaw and, finding that in a succession of, very diverse papers, documenting more or less the same set of facts rather than sort of stepping back and saying, all right, what message is this telling us about the way that the economy actually works? I think we'll take one more question for this panel, so please.
So you talked about sort of building a stronger, the right of the panel talked about building a stronger framework for merger retrospectives and actually having retrospective remedies. In a way, mergers are easier because it's discrete and you can see when it happens. And I was wondering what the analog is for monopolization. What sort of if you can't catch monopolization as it's happening, how do you see it and then reverse the harms?
I guess I can answer that. So I think that has been how monopolization has usually been approached as compared to mergers. I think mergers in some ways are the outliers, and because they do have this sort of discrete, you'll look at this tiny snapshot and hope to guess or predict as to what the effects will be. The advantage of Section 2, and one of the reasons in a paper I almost presented here, but others that I'm working right now about nascent competition, is I think the advantage of Section 2 as a method of merger review is that it has this broader look at, well, is this a pattern of serial acquisition? Have we had this company look around, try to identify its most dangerous competitors, and buy them all or try to buy them all? And that's been a kind of things. And one of the reasons I think that's slipped through their cracks is that you can win on an individual little snapshots. Oh, this one's not harmful. This one's not. That we can't prove the harm enough till we want. But you can look at a whole campaign from a Section 2 perspective, and that's what Section 2 has traditionally done. When they built the case against, I don't know who you want to choose here.
IBM.
IBM.
That was a success.
IBM was a great success. IBM is one of the most successful cases of the 1970s, and I think other people who don't think that's right are wrong. Or the case against AT&T, which led to the remedy. That involved the tools of investigation to figure out what really happened. One thing I think that is actually aiding, I want to get back to your journalistic points, is I think investigative journalists often also dig out a lot of this stuff. It's kind of, in government, it's kind of a secret of government, maybe it shouldn't be admitted. It's amazing how much the investigative journalists sometimes find more, at least in their initial rounds, than the lawyers do, and that's because they're trained in a different set of skills. So, yeah, I think I come back to a lawyerly process of getting out the facts, getting particularly to these questions of intent, what the companies thought they were doing, why they were doing them. I mean, I think in the Facebook example we've talked about, there's an email widely reported upon where Mark Zuckerberg wrote that he was buying Instagram because he was concerned that they were a potential competitor that could eventually destroy. So that seems to me as the kind of evidence that we should be going after and we should bring these cases based on. Sorry. Oh, we've gone out of time.
Yeah, you want to?
So Nathan raised an interesting point. I think Section 2, monopolization law, is probably the most interesting and challenging area of antitrust law. Mergers are comparatively easy. I think monopolization law forces us to identify what are forms of fair competition versus unfair competition. And we make that normative judgment one way or the other. So at a high level, we probably all agree predatory pricing is unfair. We probably agree that deceptive advertising is unfair. We'd certainly agree industrial sabotage is unfair. But at present, there's a lot of incoherence and mushiness around where do we draw the line. I think one of the very important near-term projects for Neo-Brandeisian school is having a clear set of normative criteria for identifying fair versus unfair competition.
And that's what Dan has challenged us. I mean, are we closing up right now?
Please feel free. Go ahead.
If we're, I take Dan's challenge seriously, and I think we, as I said, I take all of our commentators' challenge, but particularly this challenge to come up with a statement of what are the values that then can be operationalized is, I think, a priority, and I really welcome these contributions. We have our agenda in front of us. We need to figure out what our core values are and what are the 8 or 10 things we believe need to change, and just keep beating on that drum until the day is won.
Thank you. I think that's an inspiring place to leave it. Thanks to this panel for excellent discussion of where this antitrust debate lies. I hope everyone will stick around for lunch in this afternoon's panels. I think, do we get started again at 1 p.m.? Is that? Yeah. What time do we reconvene? 1 p.m. Okay. Yep. So thanks for coming.